Welcome everyone to the Computational Antitrust Exploring Antitrust 3.0 conference. My name is Roland Vogel. I'm the Executive Director of Codex, the Stanford Center for Legal Informatics, and it's my pleasure to welcome you on behalf of Stanford Law School and of Codex to this unique three-day event. Codex's mission is to advance the state of the art in computational law. Computational law is the automation and the mechanization of legal analysis. And earlier this year, we launched a project called the Computational Antitrust Project, which explores how legal informatics and computational law can foster automation of antitrust procedures and improve antitrust analysis more generally. I would like to thank everyone who has helped in putting this event together, especially, of course, Professor Thibaut Shrapnel. Thibaut is Codex affiliated faculty. He's a professor of law at the Vrije University of Amsterdam, and he's really the founder of this project in Codex. And not only does Thibaut have a tremendous vision for bringing computational law approaches to the antitrust space, but he really is tremendously dedicated and shows tremendous grit in actually making things happen. So we're really fortunate for Thibaut driving this initiative with the team he built of Stanford students and other collaborators. And so thank you to all of you. Thank you to the Stanford Law School Program Group for helping with logistical aspects of this event. And without further ado, I will turn it over to Thibaut.
Thank you very much. It's funny because we didn't coordinate, which will be an antitrust infringement. But most of what I will be discussing in just a minute actually ties to your very kind introduction. So welcome everyone, warm welcome to Antitrust 3.0, something to be discussed during those 3 days. I am thrilled to welcome you, to welcome our speakers, members of the advisory boards, academics, practitioners, officials, computer scientists. I've seen a few in the room, lawyers, economists, philosophers, and who knows, maybe unicorns. We have quite a program for you those days. Indeed, 3 days of discussion about computational antitrust. But now I thought I will be kicking us off with a little story. When I joined Codex during the summer of 2020, I had a first meeting with Roland, Professor Vogel, the center executive director, and he gave me carte blanche to start a project, which came as a surprise. I'm not used to the Silicon Valley spirit, but excited about the idea. I went to my favorite cafe down the street here in Amsterdam, and I thought about it. And of course, you know that Codex is known throughout the world for its leadership in the field of computational law. And having a PhD in antitrust, I thought that I would be first researching articles dealing with computational antitrust, and that I will take it from there. But to my surprise, I couldn't find a single article in which the terms computational antitrust were used or discussed. So immediately, I thought, this must be a bad idea, if not a very bad idea. There are, as you know, 10 gazillion antitrust articles published every month. So why would we be the first? But then I talked to antitrust agencies, and here again, to my surprise, you showed an immediate and unanimous interest in the idea. So the project was born, or at least the idea of it. But as you mentioned, Roland, indeed, we are both academics, and I especially feel the challenge of leaving the field of ideas and moving to practicalities. And as the French comedian Pierre Desproges once said, and I quote here, "One day I will go to live in theory, because in theory, everything goes well." So computational antitrust, I thought, deserved more than being stuck in theory. And the project has therefore become a reality with the help of a fantastic team. I know that most of you are in the room right now, and I'm not going to start mentioning name, but I can't help but to mention Roland and Maria and Monique and Alex and Theodora and Maura and a few others for helping and running the project. So to all of you in the room, thank you very much. We, I think, already came a long way. We have been quoted in the New York Times 3 times this year, quoted in the academic literature, and by agencies who, for some of them, are creating related programs, something to be discussed, especially on Wednesday. So all that to say, the Computational Antitrust project is and was made possible only for the support we received from all places. And importantly, I think it exists because of you in the room right now. We have over 700 registrations for the conference. And your interest in what we publish and organize is the reason why we do all this. So now back to today, December 13. As I was telling you, we have quite a program for you. I will first introduce computational antitrust with a 20-minute presentation whose objective really is to tease you as to what is coming. So I will be giving an overview of what we've been publishing and the kind of work that we do. I will then moderate a first discussion asking whether computational antitrust can succeed. As you can guess, the answer won't be fully negative, otherwise this will be the end of the 3 days conference already. After that, Alessia will take the upper end to moderate a discussion on antitrust by algorithm, and I will moderate the last discussion on the legitimacy of digital market surveillance. So without further ado, again, my objective here is to draw the portrait of what is computational antitrust. And for that, I need to just share my screen. So as you can see, I have the ambition of discussing 3 different subjects here. The first, what is computational antitrust, in case you've never heard of it and tune in by mistake. We hope that you'll stay with us. The second point is, how do we implement computational antitrust? And the third is, when do we do it? And so without further ado, I want to indeed address those 3 points right now. So to the first, what is computational antitrust? The idea of computational law is actually very old. I think it's fair to say that it was kind of introduced, or at least the idea of it, not the terms, but the idea by Leibniz, a German philosopher, who already in the 17th century said that with the right tools, it would be possible to calculate legal outcomes, or in fact, all the social outcomes. Of course, this was a dream. At the time, Leibniz never argued that this would be possible to achieve. And what we see is that when we transpose that to the field of antitrust, that there is indeed a mismatch between the time of market and the time for law. And this creates a problem. And so the idea for the project is to see if we can calculate just a tiny fraction of antitrust and automate procedures and substance so that we can close the gap a little bit. So that's the very basic idea. To be more specific and to give you some numbers that you may have seen, and if you are a practitioner, you are aware of that, and same if you work for an agency, we have a big problem when it comes to detecting anti-competitive behaviors. The empirical work is clear. In the US, in Europe, and in fact, it's hard to find empirical work outside of those 2 continents. For Latin America and Asia, I believe that the numbers are quite similar. We detect about 10 to 20% of all infringements to antitrust. So long story short, if you infringe antitrust, in all likelihood, you'll be fine. And in fact, what we see is that, unfortunately, antitrust agencies do not have the means to be proactive. And the OECD is clear-cut on that. 80% of all cases in Europe and 90% of all cases before the 2 agencies in the US are coming from reactive methods. What it means is that they generally wait for a company to complain or another company to apply for leniency. But when it comes to go out there and identify practices themselves, unfortunately, they cannot conduct such studies, or at least to a small extent. So that is the picture. In this conference, we're going to discuss solutions and be on the positive notes, but to stay negative a little bit more. Unfortunately, I think that if we do not use computational antitrust, things are not about to get better. To just give you some numbers, in 2020, we produced 44 zettabytes of data. 1 zettabyte equals 1 trillion gigabytes. So it's basically a lot of data. Already what we produced last year is 40 times more bytes than there are stars in the universe. So that's a lot. But if you look at the number, from 44 zettabytes, we're going to go to 175, or something which is in that order in just 4 years from now, 600 in 2030, and over 2,000 zettabytes of data in just 15 years from now. So it seems that, again, without the right tool, it will become increasingly difficult to detect anti-competitive behaviors. Another problem that we have is that even after the detection of practices, we may have a problem when it comes to analyzing the quantity, all the data that we have. To be very specific, the European Commission told us that in the Google Shopping case, they had to analyze 1.7 billion search queries. So needless to say that you need to use some computational tools somewhere. And another example is the one of the CMA, and there will be potentially, I'm sure, discussing that on Wednesday with Stephen Hunt. They got access to Google and Bing search queries for just 1 week and ended up between 3 and 4 with 3 and 4 billion entry points to analyze. So here again, you see that quantity could be a challenge. And of course, the nature of the data is also a challenge. As we know, unfortunately, when it comes to antitrust, we focus very much on static variables, because those are the ones that we know how to analyze. And when it comes to understanding the movie of markets, we are actually not so good. And indeed, if you are in antitrust agencies, you need to have something solid. You need to be able to make a decision on the basis of something that you can explain before a court. And so that is why they tend, and I understand why, and everyone understands why, to analyze those static variables. The objective of computational antitrust could also be to move toward dynamic variables, something to be discussed during those 3 days. I think that against this background, we have two solutions, really. Solution number one, which I frame here in a bit of a provocative way, we give up. If we give up, we could say that the market will take care of it, which is true most of the time, but it might be that the market will need 50 years to take care of it, right? For a monopoly to disappear. So is that good enough? I don't think so. Or sub-solution number two, you do what I call the minority report. I don't know if you've seen the movie. Spoiler alert, it doesn't end well. But the idea in the movie is to prevent infringements even before they happen. And this is kind of a tendency that we see in the field, the idea that you could do competition law by design and that no one will ever infringe competition law. We need here to discuss ex-ante regulations. But again, we know that companies will try to escape and argue that they are not within the boxes of those ex-ante regulations. So you end up again with the need for computational antitrust. Here, I'm going to give you two Thibaut Schreppel, because indeed, as you can see, I am definitely in favor of the one that is over here, computational antitrust. This should not be a surprise. But for now, I want to explore, why do we need computational antitrust? I know we have lawyers in the room. So if you are in need of a definition, here is the one that I like to use: the automation of antitrust procedures and the improvement of antitrust analysis, knowing that what you do is an encounter between computational tools, which are computer-based problem-solving methods, and antitrust law. Here, I just give you an overview of a few of those tools, but that is something that I want to discuss in the next 10 minutes. So how do we do it? I think that the big question is indeed, if antitrust without computer science is like Sherlock without Watson, the question becomes, which Watsons do we need, right? Should you work for a company, a firm, an antitrust agency? Should you be a computer scientist? Where do you go? What do you do? How do you design those computational tools? Here, what I want to do, as I told you, is just to tease you a little bit and to give you a flavor of some of the discussions that we're going to have during those 3 days, knowing that the only thing that I will be discussing right now are the articles that we published already. but not the ones that are already scheduled for this conference, but which are not being published yet. First, when it comes to anti-competitive behaviors, we know, as I mentioned, that we have a problem when it comes to detecting practices. An idea which has been explored in a few of our publications is to use market screening tools, something to be discussed later on today. It could also be that you want to design APIs so that the data could actually be transmitted from agencies to companies and vice versa, or that you use natural language processing, which is a machine learning based method, according to which you provide the machine with lots of documentation and ask for the machine to identify patterns, whether or not you have flagged those patterns before, something to be discussed today. So that's number one. Number two, as I mentioned, the analysis could be improved. It could be that you want to use more than just competition documents. It could be that the documentation in the hands of other agencies could be helpful. And here I am referring to the 10Ks, for instance, which are in the hands of financial agencies and in fact, in the public domain. Those could prove helpful when it comes to better understanding market dynamics. So here, this is just an overview of what could be possible when it comes to detecting and analyzing practices, but something where we know all antitrust agencies could start from is an idea which was mentioned in an article by Bill Kovacic, who is to intervene in this conference on Wednesday. And the idea here is that all antitrust agencies could in fact start from their own case law. And here, this is the second article that we published. I've put the QR codes if you are interested, but something to be sure discussed during this conference. The idea and what they've done, and here I'm quoting Mazzarotto and Itu, is that they trained a machine learning system based on the FTC case law and actually came up with some very interesting results. Here again, I'm just here to tease you and not to explain the methodology because they will actually be giving a presentation on the subject. When it comes to the sanctions, another article that we published, co-authored by 3 gentlemen who worked on the Microsoft case, and what they show is that when Microsoft was ordered to generate the technical documentation to ensure interoperability on the market, they first assigned the task to 10 employees, and they ended up with over 800 employees. And here again, the idea is, can't we just use computational tools so that we can automate parts, if not everything, of the sanctions and the remedies imposed to companies? So this was subject number 1, anti-competitive practices. When it comes to subject number 2, something that we'll be discussing also, especially tomorrow and on Wednesday, merger control. What we see here is that, of course, the issue is not the same. Most of the companies do notify the mergers when they have to. So there is no detection issue, but there is an issue of time and an issue of trust. Can I trust that the data set is complete when I work for antitrust agencies? And when you work for a company, it's actually really hard to provide the agency with a complete data set, especially when it comes to guessing what is the turnover of your competitors and the market shares. And here, I'm just showing you 2 examples of a complaint, which is quite regular by the European Commission, according to which they were provided with incomplete databases, whether or not this is on purpose. It seems to me that blockchain could help here in the regard by ensuring that all the companies have a secure database and could actually provide agencies with access to their private blockchains, something that is being discussed in the QR code here up on the left corner. When it comes to merger control still, another article that we just published last week is actually exploring how we could use internal agency data to improve merger control analysis. Between the FTC and the DOJ in the last 20 years, they had to analyze over 30,000 different mergers. And so it seems that this kind of data could be helpful to better understand the future. And it could be that the data is also coming from outside, meaning on the market, to better predict what will be the impact of a merger. On that subject, And here again, another paper to be published, to be discussed on Wednesday by MIT scholars. What they've done here is that they have analyzed what they called the fitness of a company, which is the link between a company's growth and the amount of connection that these companies has with other companies. And they show that there is a correlation between those two. And it seems that indeed, when it comes to addressing killer acquisitions, this is the kind of data that we may want to take into account on top of considering the turnover and the market shares. This was for merger control. Third and final point, policies. Here, and this is an article that we haven't published yet, it seems that one priority would be to indeed conduct retrospective studies to better understand what has been the impact of antitrust policies and antitrust decisions on the markets. But something that we've been publishing already, and that again will be discussed tomorrow, is the idea to use machine learning to better draft policy. What they've done here in this article is that they have analyzed all the contributions made to the European Commission when it comes to the Digital Markets Act, and shown that depending on the size of a company, you do not understand those keywords here, dominant, gatekeepers, monopolistic, etc., in the exact same way. And so it seems that this kind of information could be very helpful when it comes to actually better drafting policies that are being understood the exact same ways by all the actors on the market. Something else, another paper that we published is the use of machine learning to analyze past case law to see that there are trends. Here, for example, the amount of cases discussing tying is declining. And this could be helpful information when it comes to enforcing more of such cases, or on the contrary, potentially putting more of your efforts on other type of practices which might be more trending on the markets. And last point, when it comes to policy, will be the use of agent-based modeling, something that we'll be publishing earlier next year. The idea here being that you are actually trying to create a computer simulation and assigning value to all of those agents. You could see when you change the environment, the environment being here, for example, a legal rule, or to introduce a new competitor on the market, you could see that those agents will go to the right or to the left, which will be the equivalent of exiting the market, or on the contrary, investing more on the market. Again, something that we'll be publishing earlier next year. So all that will lead us during those 3 days to discuss improvements to antitrust such as it exists, and slowly but surely we'll be discussing how we could change antitrust law, and not only here from a methodological point of view, but also impacting the actual substance of what is antitrust. So when do we do all that? As you can guess, the answer is now. You might be aware, I suppose, because you are here today, that we have indeed created a computational antitrust project. You can access all of our articles and podcasts and all the news on the Codex website. And so we are right now engaging in publishing more articles and more podcasts, something that is soon coming up your way. Here, I need to disappear a little bit because I just want to show you the team behind the project. Again, a big thank you to all of them. You will be seeing most of them as they will be moderating panels in the coming days. And so with that in mind, and here I'm just gonna, I just wanted to show you the overview of the advisory board. And again, thank you very much for all of you who are commenting on articles today or on the Tuesday and Wednesday. I just want to here to showcase a few of the key figures for the project, most of which I mentioned already. I can tell you that we are very pleased, but something which is clear is here at the very bottom. This project is 100% Codex. The encounter between computational law and antitrust, I think, was only possible within the Codex Center. And so for that reason, again, Roland, a big thank you for everything. Here, this is the overview of all the competition agencies we are working with. I believe that most of those agencies are in the room right now. And as you know, if you have more questions, feel free to always come back to me. Some of you have accepted to present the use of computational tools within your agencies. And so a big thank you. And again, we will be publishing a report in just a few weeks in which most of those agencies will explain the use they make of computational tools. So as you might be aware, we publish one article every month. Then we do publish a podcast episode that goes with it. And we are right now organizing our annual conference. I can tell you already that the objective is to organize another one in December of next year. So we hope to see you then. But I couldn't leave this presentation without mentioning a few of the challenges to be discussed during those 3 days. Challenge number one, which fields of antitrust law can we compute? It might be easy to compute predatory pricing. It might be much harder to compute innovation-related practices. The quality of a product is something which is really hard to compute because really hard to put in a system and to know according to which criteria we will measure if a product is innovative or not. And so this is one of the big challenges that we are facing. Challenge number two, which tools, who should be developing those tools? If they are developed by agencies, according to which standard should they actually share those tools? If the tools are being developed by the private sector, should agencies use those tools, et cetera, et cetera? Should they be open access? Also something to be discussed. Challenge number three, the role of computational antitrust. Here, quoting a Nobel Prize winner, George Akerlof, there are important topics and problems which are difficult to approach in the hard way, meaning using mathematical formula. And I think a big mistake will be to say everything that cannot be computed will be excluded from antitrust. On the contrary, we may want to have some standard according to which you could create a balance between computable versus non-computable elements. Challenge number four, procedural fairness, something that Daryl actually mentioned and discussed in his paper. A big question might be, of course, if one of the company has a lot of computational power, and if that company is facing a startup with zero computational power or a company outside of the digital market, what do we do? This is, of course, a challenge to be solved. And the last one is to know the limits. In my view, it would be a mistake to think that we can predict the future using computational tools. It might be possible one day. If you are interested in the idea, there is a great TV show happening in Silicon Valley called Devs, but this is not something for today. So in my view, again, very important to know the limits of computational antitrust. All that to say that there are challenges and we are facing the limits of computational antitrust, but what we see is that the same is true for weather forecast, and yet, according to empirical research, the quality of weather forecast is actually improving over the last 30 years, especially because machine learning and other AI techniques are being used. And so the idea for the project is that if we do not want to be stuck living the same day over and over again, meaning here not being able to improve antitrust because we are making no use of the data that we have right now, a good solution would be not to use computational antitrust. On the other end, if we want to leave that, of course, computational antitrust could be one of the solutions that we may want to explore. The challenge here is to actually create a encounter between the substance of what we see on the market and the method which is being used by companies, law firms, and antitrust agencies, hence Antitrust 3.0, the first one being the antitrust of the Sherman Act, Antitrust 2.0 being here, antitrust with economic theory, and the third being antitrust with economic theory and computer science on top of it. So this was, again, the overview of all of the discussions that we are going to have during those 3 days.